It was really exciting watching Prince Harry in court over the last few days as he gave evidence in his trial against Mirror Group newspapers. But in reality, we're only really in the middle of proceedings, and they're actually set to continue on until the end of June. In light of this, and in light of the complex legal issues that are really at play here, we thought it would be a great idea to interview a legal expert to tell us what we can expect and what we need to be looking out for. The person I had in mind for this was Colette Allen. Now, Colette Allen has been a media law commentator for some years now. She is one of the hosts on the Media Law podcast and also a contributor to the Inform blog. She also qualified for the Bar of England and Wales back in November 2020. So obviously Harry was on the witness stand and he was being cross-examined. There's been a lot of speculation about whether he did well, what to sort of people kind of assessing his body language, assessing how he seemed, looking into the finer details of his answers. As someone who is familiar with the law and with media law specifically, could you kind of talk us through how in a trial like this, the process of calling witnesses in the first place works?
Sure. So if a party in any claim wants to prove a fact, which can only be proved by the evidence of a witness, that party has to call that witness to give oral evidence at trial. So in a case like phone hacking, which goes back 15, 20 years, a lot of the articles that are complained of, the only evidence that phone hacking was involved would come from Prince Harry himself. There aren't necessarily phone records that can go to prove that. So this is why Prince Harry's been called and has to provide evidence live in the hearings over the last couple of days.
Mm-hmm.
In order for a witness to appear and give oral evidence in court, they must first submit a written witness statement. This is a formal document containing the witness's own account of the facts of the issues in disputes, and comments made in the statement are limited just to facts. So there should be in theory, it should be limited to a factual account of what the witness knows and not their opinion. Obviously, as you mentioned, there's been a lot of speculation around his opinion of the press and that coming through maybe in some of his evidence, but that at its core, what a witness statement should be is about fact. In civil trials, you then have that witness statement forming the bulk of the evidence for the party that calls the witness. So you don't need to ask Harry to come in and then read out that witness statement. Everything that's been written in that witness statement is now provided as fact. And that's one way that the civil courts distinct from the criminal courts, because the criminal courts require every bit of evidence that you want to rely on to be spoken out loud in court. What we're seeing now over the past few days with Harry is the cross-examination, which is done by the opposing party's barrister to test the veracity of that witness statement. So every bit of oral testimony we're getting from Harry is through that process of cross-examination. He's being tested. Those questions are leading. They're trying to trip him up a little bit on any inconsistencies in his accounts. And trying to advance the other party's case. So his answers in what we're seeing of the answers given in court are all reactionary. They're not the positive account given in the written witness statement.
And is it the case that everyone who writes a witness statement has to come in and be cross-examined, or how do they decide who gets cross-examined?
So it's up to the parties. If a party wants to dispute anything in a witness statement, then they have to call that witness in for cross-examination. Anything that is disputed between the parties has to be put to a witness that provided that evidence in cross-examination. And if it isn't, then it's taken as fact. So that's why you've also got this really forensic process from the defense barrister for MGN, going through every line of that 50-page witness statement from Harry and questioning every little detail about it. Because if he left anything out, it would be taken as, okay, parties agree to this particular aspect of what's in dispute. And obviously MGN's disputing a lot of what Harry's saying. So that's why he's got to go through line by line.
So you kind of answered already what the barrister is trying to do when they cross-examine an individual. Is there anything else you can add on that? Perhaps something specifically in terms of Prince Harry's case and Prince Harry's interactions that you've seen with his barrister, with Andrew Green?
So I think a notable element of the cross-examination we're seeing with Prince Harry is the approach taken by Andrew Green. He seems to be going through quite a soft approach, recognizing that the public don't approve of things like phone hacking. And, I think it's notable that the first question, or before he even asked the question, of Harry yesterday, he apologized for the intrusions that MGN has admitted to. And so that's something that barristers have to strategize before they go into the cross-examination, the approach they want to take. Sometimes a softer approach can be much more effective, and it can make the witness seem like they're overreacting, and that actually the reasoned one is the respondent or the defendant in a case. Other times it might be more appropriate to go in harder and make the witness appear like they're lying, or like they can't be trusted, or have misunderstood what has actually happened. I think what we're seeing here in this approach is more, we understand you've had great difficulty at the hands of the press over your lifetime, but this case doesn't seem to be actually related to the 33 articles you're complaining of. You're using it as an excuse to raise concerns that you've had about the press in general over your lifetime. And so that softer approach works a bit better with that strategy for the argument that the defense counsel seems to be advancing here, which is, it's not really about the 33 articles. It's about your wider problem with the press. And that's not what the court's here to decide today.
And the barrister's audience in that is only the judge?
Yes. So in civil trials, you don't have a jury. In technically, there's still a route to have a jury in defamation trials. This isn't a defamation trial. This is a privacy trial. But they're really rare, very, very rare now. So civil trials are just for the judge. Having said that, this is Prince Harry's made no. He's been very clear that he wants to see press reform, and this is the route he sees as getting that reform that he believes is necessary. So in many ways, he is playing to the court of public opinion, because what he is essentially wanting is a regulatory reform, which would come with people watching the trial, seeing the press misbehaving, building up momentum behind campaigns for press reform and press regulation, and going down that way. So it's a slightly unique trial in that sense, and maybe some people would call it a show trial, in that it's not just for the judge necessarily. There's also a huge element of the court of public opinion at play here.
Mm-hmm. And is that something that Andrew Green himself would be aware of or be taking into account?
He'll absolutely be aware of it. He won't be taking it into account because it's not something the judge will be taking into account. So Mr. Green will be advancing a case that he knows the court has to apply the law. He's advancing a case based on law that benefits his client's position. And it's not his responsibility to worry about the way that the public interpret this entire thing. It is, in reality, it is something that Prince Harry will have to think about, because, as I say, he's doing this in the wider context of wanting to build a campaign for press reform.
Makes sense. And then I guess on to Harry's own sort of performance, if you like, on the witness stands. How much preparation, if any, is allowed to take place involving his own legal team?
Typically, the barrister will work with the witness to discuss the issues on which that witness can give evidence. So this will involve the lawyer asking the witness to review the documents that they might have received as part of the document exchange as standard court procedures. So these are documents that the witness might not have seen when they decided to bring the claim. And then the lawyer will ask questions about important events that the witness will obviously want to raise in as part of their witness statements. But the witness statement is written in the witness's own words. It's not written by the lawyer. And even more importantly, there are very strict rules around training or coaching witnesses. So anything that could be seen to cause a witness to tailor their evidence in a particular way because of what their lawyer has said is not allowed. And to that effect, it would also be very inappropriate for a lawyer to do a mock cross-examination, for example, with their witness. So the cross-examination you're seeing now of Harry is him answering questions. This isn't rehearsed.
And then I suppose taking a step back to looking at the trial overall, maybe, part of that is Harry's testimony, but it's a long trial in and of itself. As an observer, how do you perceive it as how's it going?
I mean, yes. So it's difficult to comment when you're trying to filter through all the reporting. And obviously, I've not actually been in the court myself, so in many ways, more than I do with this. What I would say is that this appears to be a case largely built on inference. So the claimants here are essentially asking the court to make a judgment based on circumstantial evidence in the context of MGN's previous admissions to phone hacking. And we know that MGN has admitted to phone hacking in the past and indeed admitted to paying a private investigator. Now, it's not to say that context isn't relevant or that those previous admissions aren't relevant. But as far as privacy cases go, it does seem to be one that's more based on, well, this has happened before, so it must have happened in these instances too. And a judge will only let inferential evidence can only be so convincing. So it's not to say that that cases aren't decided solely on circumstantial and inferential evidence, but as a whole, it seems to be more reliant on that kind of evidence than other privacy cases that I've seen. Whether it works or not, I don't know. Only time will tell. And it's worth noting as well that we're only partway through the examination of witnesses. A lot can change when different witnesses come in and out. But at the moment, what I would say is that it does seem to be one of inference, and that is a fairly difficult position for a claimant to advance, because the claimant obviously has the responsibility of convincing the judge that on the balance of probabilities, their version of events is right. And if everything's based on requiring a judge to make leaps, then they might be more hesitant to find in favor on that, over 50% in favor that the case should fall for the claimant.
Moving on to the kind of implications that this, I suppose it's already having implications, the fact that it's even happening, the fact that it's advanced to a public trial. There's been a lot of interest from America in the trial. They have a slightly different legal system to our own. There are aspects of our legal system and aspects of our press that people in the States might be unfamiliar with or struggle to understand. Could you kind of talk us through vaguely what the differences there are, and perhaps ways in which our legal system might change to be more like the American one as a result of this?
Yeah, so obviously I'm not trained in American law, so there's a limit to how much I can draw comparisons. The one thing I would say that's most obvious is that with any form of dispute relating to publication, the First Amendment in the US makes it very difficult to bring a successful claim against publishers, because there's we have strong free speech rights here, but First Amendment is very strong in the US. Having said that, it's noteworthy that this hearing relates to phone hacking, and is brought under the English tort of misuse of private information. Misuse of private information is the only route to bringing a successful privacy claim in the UK. In the US, they have different heads under their umbrella of privacy law. So one of those heads is the intrusion tort, which in many ways might be more appropriate to a situation which we have here, where there's phone hacking involved. Obviously, in these cases, the position of the claimants is that their phones were hacked, or that information was gathered unlawfully via blagging, and then it was published. But there will be, what Harry's essentially trying to prove is that there was a system of unlawful information gathering that used these techniques. Sometimes these techniques would have gathered juicy information worthy of publication, and there was publication, and that's why you have the case that's happening now. Other times, there'll have been a lot of information that was gathered which didn't seem noteworthy, and so nothing ever came of it. Claimants in those positions in the UK have no right to recourse because there's no action, there's no misuse in the way that the English court understands privacy for them to bring a claim on. Whereas in America, there would be. So you asked where maybe the law might develop in the UK as a result of these hearings. And one possible route that I think myself and many other legal commentators familiar with this area of law could foreseeably predict is that the UK courts decide it's time to follow the approach of other common law nations like the US, Canada, New Zealand, and introduce an intrusion tort into UK privacy law. So not just the publication of that information, but any information gathered through unlawful means like phone hacking is seen as a violation of privacy, and the people who have been violated in that way deserve a right to compensation, and this is the route to get it.
Would you say that means that this case, much like it is being followed a lot by the press, by individuals who are interested in the royal family and the media, would you say that it is also seen as a landmark case amongst legal professionals as well, and that it's being followed with interest by people that you work with and people who are broadly interested in media law?
This case specifically, less so, because what MGN is saying as their defense is we didn't do any of this phone hacking, we didn't do any of this this blagging that we've been accused of. However, it's worth remembering that this is the first of 3 phone hacking litigations that are coming through the pipeline. So you're going to have 3 judgments, assuming that the other 2 make it through the preliminary stages. You're going to have 3 judgments that are dealing with this issue of phone hacking and intrusion. It might not be the case that all defendants run the same kind of defense of just flat out refusing that any of it happened. There might be more nuanced defenses that say, well, that question the extent to which any phone hacking is actually a misuse of private information. And that would be the routes by which the courts would have to answer a question around whether we need to expand this privacy tort or not. That's the most obvious way that it would happen, and I think that's what legal commentators and professionals are waiting for, is to essentially see the defences that will come through in the other phone hacking cases. But it's not to say that the issue isn't addressed in this judgment, and it might well do. It might well be a case that that phone hacking is found, and then the judge will obviously have to address how that relates to the law, and may well leave comments and questions for judges that we know are going to have to address these issues in the very not so distant future, to open up this conversation around how do we tidy up misuse of private information, because as it stands, it's a tort that's in theory very narrow in its remit, but we're trying to shove in lots of different ways that their privacy can be violated into this one single tort, and it gets messy, and it might be better for a separate head to develop. Having said that, any legal commentators or lawyers who are listening to this will know how difficult it is to introduce new heads of liability in English law, and that's something that will then go through the appeal process. So it's easy for me to sit and comment from the sidelines and say, oh, this could happen and it would be great. But these things take a lot of time, and they would go through a considerable amount of appeals. So it's something that obviously people interested in this field are watching out for. It's not something we necessarily expect from this judgment, but it's something that is on the horizon, and might the start of this consideration might begin in this judgment.
Brilliant. Thank you so much. Really appreciate your time. That was all so interesting and so detailed, and really helped to put everything that's going on at the moment into perspective. Also very useful knowledge to have as we keep following the litigation that's going on with News Group and with associated newspapers as well. So yeah, thank you so much for your time, and have a lovely evening.
Thank you. Yeah, no worries at all.
Now, hopefully that offers some context and shines some light on the kind of detail that we need to be looking for as proceedings continue over the next few weeks. We will obviously be following along and would love it if you could keep up to date with what we're publishing. If you want to do that, please do subscribe to our YouTube channel and support our journalism via